thank you all for being here. This is the Gazette Mail interview with the candidates for Supreme Court of Appeals of West Virginia. We will ask each of y'all to introduce yourselves in a moment. Again, this session is being recorded. You are meeting with the editors of the Gazette Mail, with the Gazette and Daily Mail opinion page editors as well, who will do separate endorsements, and then a reporter from the Gazette Mail for a Sunday story, anticipated for Sunday story. So we will begin here and each go through and introduce ourselves, and then we'll ask you, starting with you, Mr. Wooten, we'll just go around the room. Introduce yourself and give less than, say, a 30-second introduction as to why you're running, and then we will go with questions.
I'm David Gutman. I'm a reporter for the Gazette Mail.
I'm Brad McElhenney. I'm co-editor of the Gazette Mail. Thank you for being here today.
Yes. I'm Kelly Merritt. I am Daily Mail opinion page editor.
I'm Whitney Burdett. I'm an editorial writer for the Daily Mail opinion page. I'm Dawn Miller. I'm the Gazette opinion page editor.
I'm Greg Moore. I'm the city editor of the Gazette Mail.
And I'm Rob Byers, the co-editor of the Gazette Mail.
Mr. Wooten.
I'm Bill Wooten. I'm a candidate for the Supreme Court of Appeals. I'm a lawyer from Beckley.
And I'm Beth Walker. I'm a lawyer in Morgantown, and I thank you all for having this forum today. I'm looking forward to discussing the importance of this race to the future of the Supreme Court of Appeals.
I'm Darrell McGraw. I'm a candidate for the Supreme Court, Justice of the Supreme Court.
I'm Brent Benjamin. I'm currently a justice on the West Virginia Supreme Court, and I'm running for re-election.
I'm Wayne King from Clay, West Virginia, and I've been practicing law in Clay for 43 years.
Again, thank you all very much for being here, and I'll get started with the questions. And we'll start with you, Mr. King, and we'll just go in reverse order here. So, there's been discussion for years in West Virginia as to whether the fairness of the judicial system and whether or not one thing limiting fairness is a appellate court, intermediate court of appeals. Now, in 2011, the Supreme Court did adopt some standards to say everybody has a right to appeal, but some might argue that's more of a right to review. Should there be a true intermediate court of appeals and another appeals court at an intermediate level?
No, I don't agree that there should be. I think the Supreme Court handles all its cases in a timely way, and I would strive to do the very same examples for the justices of the case.
The Constitution permits the legislature to develop an intermediate court, and the legislature, that is a legislative decision, not the courts. The legislature this term decided not to go forward because it was balancing a lot of factors, and I agree with that decision. But ultimately, it comes down to benefits and detriments. There are costs to a middle-level court, whether it's the added level of government or the cost to litigants in extra time, extra attorney fees, and so on. And I know the legislature looked at that. The benefit is having an extra set of eyes looking at things, and also having an extra set of jurisprudence by which people can govern their affairs. And it ultimately does come down to that balance. And in this case, the legislature, I think, in the current budgetary climate of the state, decided that now is not the time to go forward on that. I would say, though, that there are options that are out there. Other states have what are called, that are roughly our size, have options that are available in the form of middle-level courts where they don't always sit, and they only sit for certain cases. And those are some of the options that I think the court can look at. Ultimately, I think an extra set of eyes is a good thing, but it must be weighed against the costs.
I tend to agree with the statements that have already been shared, but the answer to the question in Matthew would be no. The burden is not so great that the intermediate court should be created, and the intermediate court would in a way be an obstacle to the pursuit of justice, because it's another barrier between the Court of General Jurisdiction and the final appeals court, which inevitably would be the target of anyone with an appeal.
As Justice Benjamin pointed out, of course, it is the prerogative of the legislature to determine whether to create courts, including an intermediate court of appeals. My concerns are really twofold as far as input into that decision, which ultimately, again, is the legislature's. One is, of course, budgetary. That's certainly a consideration. The other, I expressed, just to echo, when I ran in 2008, I talked a little bit about concerns about another political branch of the court, so to speak. Those concerns have been allayed quite a bit by the action of last year's legislative session, making this race and the race of the entire judiciary nonpartisan. So I couldn't be happier, frankly, about that development. That is, of course, less a concern now. But ultimately, I trust the legislature to make that decision. We're in a pretty tough budgetary time, and I think that they weighed that into what the possible advantages would be, and I trust they'll do that in the future.
The Judiciary Amendment adopted to our Constitution in 1974 authorized the intermediate appellate courts. In every legislative session since that time, there's been some under-the-table discussion, if you will, of that fact. No legislature has seen fit to create that court. I think primarily for budgetary reasons and also balancing the workload and the perceived need for such a court. As was pointed out, as you pointed out in the question, with the adoption of the rules change in 2011, every case now gets reviewed. I believe that meets the needs of the people of West Virginia. Certainly when you balance those needs against the budgetary situation we're now in and the cost of the intermediate appellate court, this is not the time to have such a court.
So the Supreme Court oversees and makes appointments to the Judicial Investigation Committee, which is charged with determining if a justice, any judge across the state, has violated the code of conduct, among some other things. Do you think there's a conflict of interest when the JIC must rule on a complaint against a Supreme Court justice? And do you think that there needs to be some sort of board or commission free of Supreme Court influence to oversee those sorts of complaints? Sort of, Mr. Wood,
I think that the current system works well. Someone has to make the decision. If it were not the Supreme Court, it would be perhaps a different branch of government. But the current system works well. It's my understanding there are lay members on that commission that provide a perspective that's certainly not influenced by the board. I think the history of the court indicates that no influence, no undue influence certainly has been exercised by the court. I think it works well.
I can certainly understand concerns that have been expressed about the Judicial Investigation Commission. The problem that I see, or the challenge when you start talking about someone else overlooking that, scrutinizing it, is the separation of powers. It's extremely important, in the system that our founders brilliantly came up with, that the judiciary be entirely separate. And I think if you're starting to talk about legislative oversight or executive oversight, you start, bringing into question that separation. So that would be one of my concerns and should be part of that discussion.
There are numerous viable notions about the business of recusal of Supreme Court justices, distinguished, of course, from the courts of general jurisdiction for which there is an appeal process in the instance of any question. The problem is that Supreme Court justices are appointed by the people, to analogize it to the federal situation. And perhaps court justices are chosen on the basis of let's call it a love of knowledge. I think the shorthand term for that is philosophy. And the problem that occurs is that people might abuse a process that should be in place. There should be some process in place. Let me make a point this way. Others here on this panel have heard this. When I went to the Supreme Court in my first term on the Supreme Court, in 1977, it was the first time there was a motion for recusal. We went into the conference room and I raised the issue. Now, what's the process on this? And they said, one of my colleagues said, what do you mean what's the process on this? I said, well, it is a motion to disqualify the judge. What's the process for doing that? They said, well, there's no process for doing that. I said, what? They said, well, there's no process. Every judge makes his own decision. To which I said, what? Well, the problem going on is that people who disagree with the philosophy of a judge might use the process for the disqualification of someone who they think will vote against them on the court. Now this becomes complicated because each member of the court is chosen, in our case in an election, by people who expect them to manifest their philosophy as they look at a case, perhaps. And so the system, any system might lend itself to abuse, particularly to the motions on, let's call them, I don't like this word because it's politically charged, but frivolous motions. It's something that requires study and attention and a lot of thought, but a solution, we are capable of coming to a solution on that, and it is my judgment that we should do so in this particular instance so that in egregious cases, motions for disqualification can be considered. But it would have to be all within the court system, no executive commission and no legislative panels. All of those things are supercharged with politics. It should be a judicial proceeding. I'm not going to propose, there are many thoughts on how one could do this, but there should be a proceeding to approach egregious, what might prove to be egregious cases.
The quality of the JIC's decisions are based upon the quality of the people on the JIC. To date, I'm not aware of any complaints about bias or that the members of the committee have been anything other than completely impeccable with respect not only to their credentials to be on there, but with respect to what they've done while they've been on there. So at this point, without seeing the problem, I don't see really the need to change what has served the state very well over the many years that we've had the JIC.
The Judicially Acquired Commission also investigates members like myself who are on the West Virginia State Bar Board of Directors of the governors. And I'm familiar with the individuals that are on that commission. They do, like Justice Benjamin said, do an outstanding job. I see nothing wrong with the decisions up to this date that they've been making, and they've been totally independent, totally fair in the instances I've been involved.
Benjamin, your desire for public financing is certainly a big departure from the way you were elected the first time. Does that experience, is it playing into how you want to operate now?
I think it's very important that the public know that their judiciary is independent, that their judiciary comes to the bench in a way that minimizes the perception, I think, not the belief, but maybe just the perception of undue influence or strings attached, so to speak. And certainly my experience is way into that. We did not have, in 2004, a public financing system. I've always been a proponent of it because I think it does just that. To the extent that there are concerns about undue influences from special interests, out-of-state concerns, or even the people that are well entrenched at the Capitol. The public financing system allays that. To me as a judge, the thought of, I think there's a concern, and it's shared by many judges, that in many instances, traditionally, the very people who appear in front of you are the people that are contributing to the campaign in high dollar amounts. That creates not only conflict in the public, but I think to the judges themselves, it's very uncomfortable. And in this instance, when the legislature finalized a permanent public financing system that became effective in June of last year, I felt that was the appropriate way to go for me. I'm not saying that it's an option, it's an opportunity for candidates. They don't have to do it. I'm not judging anyone who doesn't. But for me, it's the right thing to do. I believe from listening to people around the state, and it's not just one group, it's a bipartisan mix of everybody, Republicans, Democrats, union management, people on fixed incomes, working folks. Everybody seems to be very supportive of that notion. And I think it's important to do so. I think it also insulates the judge when the judge has to make a tough decision, a decision that maybe is politically charged. And we know when we're having to make those decisions and having to make those calls that there will be people complaining that say, you decided this case because of this, or you decided that the case because of that. And yes, that might be Monday morning quarterbacking or sour grapes, but the reality is they can still make those complaints. Public financing takes that away. And I think that's also an important notion. Finally, I think it's also an important notion that the person with a $1 or $2 contribution can have every bit as much impact in a judicial election as the high dollar person. And I think that's important for the state also. I think it sends a good message to people out of state that we have a fair and just and independent judiciary, but I think it also establishes that within the state.
So looking back on that first election then, do you regret the way that that all went down?
In 2004?
Yeah, your first election.
I think in 2016, obviously, I have a record. I have a factual base upon for people to decide who I am, not what I am. In 2004, there was a lot of money that came into that race, a lot of independent money. It came in from both sides. In some instances, we knew where it came from. In some instances, we didn't. And that created, I think that created a lot of the perception issues. But perceptions, preconceptions, are in other words, a prejudgment. And then people did not have facts. Today they do on me. I prefer the public financing. I think that it's good for West Virginia. I think West Virginians support the notion. I think it's across the board thing. I wish we would have had it in 2004, but perhaps because of what happened, and it wasn't just 2004, we can go back to 2000, 1998, 1996, and so on. In today's climate, with people concerned about money in politics and money in elections, I think that this is a fresh approach, and it allows us to take our court to that next level of putting it above the fray. The legislature took the politics out. I think public financing takes the special interest out.
Anybody else like to weigh in on that?
Well, I'm adamantly opposed to the public financing. I believe that asking these citizens of the state of West Virginia to elect me to an office that makes about $140,000 a year, probably 90% more than the average West Virginian makes. Why should I ask them to public finance my campaign? I disagree wholeheartedly with Judge Benjamin. He wasn't complaining 12 years ago. I disagree with people putting money in. I don't want to know where it comes from. I'm financing my own campaign to the best I can, and I think it would be a shame if I asked the citizens to help me, except to the extent that they want to contribute to my committee. As I say, public financing for one set of government versus all the others, I think it's totally.
The other branches of government are expressly political. The Supreme Court, in fact, the entire judiciary should not be political. Public financing eliminates the perception that the court is not fair. That with conventional financing, there is the possibility that the confidence of the public in the integrity of the judicial system is undermined. I think public financing cures that problem pardon me, public financing cures that problem. Certainly it costs money, but the integrity of the judicial system in the minds of the public, their confidence in the fairness of the system, I think outweighs the cost of the public financing. I think it's a great idea. I've sought public financing from the onset in my campaign. I did not enter the campaign under any other approach other than to seek public financing. Thank you.
Public financing sounds great if you can get it.
Who are we trying to kid, in fact? You know, we know people are going to be buying ads on TV, they have to declare these things. And to try to say the public financing will cure all these matters, we're just, who are we trying to kid, really?
Well-
Like I said, I will have that salary. I'm not going to ask for any benefits if I'm elected Supreme Court Justice, any expenses or anything else. I will use that salary as the sole basis for my income during the 12 years I'm justice in service state of West Virginia.
As government, West Virginia invests in all forms of infrastructure to benefit certain aspects of West Virginia. We invest in roads, we invest in businesses in the forms of tax breaks. We invest in all forms of things to create an infrastructure which establishes good government. Public financing is no different in concept. As Mr. Wooten said, the judicial branch is very different from the two political branches. For us, our legitimacy as a branch is not the power of the purse or the power of the sword like the executive and legislative branches are. The legitimacy of our branch of government is based upon the perception of the people. It's the legitimacy which the people give to our branch of government. And those things which help to legitimize the branch, such as public financing, I think are part of the necessary infrastructure that we should have in this day when we have moved to nonpartisan elections. I think this is a necessary aspect. Again, it is an option of the candidate, and it can become an issue. I appreciate Mr. King's comments and feelings. I disagree.
Good. I don't mean to cut you off, but before we move on, could I just have Mr. McGraw and Ms. Walker address what you think about the public financing system, whether it's a good idea, whether, you know.
Thank you, sir. Personally, I'm not participating in the public financing program. I can't, frankly, in good conscience, run a campaign on state funds in the midst of the budgetary challenges that we're facing as a state. I have full confidence in the process that we've established, which is, of course, a campaign committee raising money to support my campaign. I don't know who donated to my campaign in 2008, and I won't know who donated to the campaign in 2016. I think that is a more than adequate separation from who the donors might be or an influence on me as a potential justice on the Supreme Court. Of course, the public financing involves raising money just as a regular campaign does. So I think that you just have to keep that separation, and you have to have confidence as a candidate in the committee to be able to raise the resources necessary to run a campaign.
Just to follow up, do you have any objections to the system as it exists now? I know you're not using it, but Mr. King obviously objects to the system as it is now. Mr. Benjamin, Mr. Wooten do not. Do you come down that way?
I don't have any objection to, the legislature established the process. I don't think I don't think it's a good choice right now in the midst of the budgetary challenges we have. But that's, as far as I go.
Well, I wonder if it's more important to finance a Supreme Court campaign out of public funds than it is to make proper provision for hungry children to eat, or for proper schools for the children to go to. for preparation in life. Or for a more mundane proposition, patching potholes in the roads. Now, I don't know in terms of the amount of money that is currently involved in that system, that any of those things would go very far, but to reflect upon Everett Dirks, the senator of long ago from Illinois, who said, $1 million here and $1 million there soon starts to add up to something. Well, it's the same way with 100,000 in West Virginia. It's the same way with 100,000 here or 100,000 there. If you would at some point add up to $1 million. Now, there are a lot of flaws in the system, even if one accepts the notion of it. For example, in order to qualify for the program, it's necessary to begin the campaign ahead of time before the filing date is finished. What about that? Everyone who's involved doesn't get an equal shot at it. But for me, there's an irony in it. And the irony in it is that in the course of my conduct of the state's business in the Attorney General's office, we recovered for the benefit of the taxpayers of the state about $2 billion. Now, I read lately about how they're now thinking about dipping into the rainy day fund. And there will be people who analyze these things who say that the source of the rainy day fund is in main portion money that was accrued by the Attorney General. So the irony of the current situation is that in my campaign and election to the court, that I am facing resistance from money that I'm responsible for having put into the treasury of the state. And I don't know whether that would be fair or not in the minds of some.
Just to follow up,
It strikes me as an issue. I could go on and on about it. Not to speak of the notion of when people talk about power, executive power, legislative power, judicial power. When I went to school and was listening to what they said, they talked about power in political science. And one of the things that they ventured a notion on was that all acts of government are political. And that's something that they were teaching in school in terms of colloquial understandings. That's perhaps not something that is universally understood that way.
Just to follow, the money that they're asking the state of West Virginia to give them, if you divide that by 55 counties, that would be $18,000 each C%. Just think of that. I'll guarantee you one thing also, you won't see me on the Riviera, on the beach, when somebody has a case before the court.
Is that a specific reference? I can't help but notice you're still trying to get the money.
I'm not trying to do that.
March 23rd, I believe, there's a hearing before the Supreme Court, which will have 5 alternate justices, right? Correct. Is it really helpful to have if you don't have it? That'll put you about a month out from early voting.
Well, obviously, what we see here is the coming together of the concept and the desire by the legislature representing the people to have public financing, with the concept that we wanted to change how we get judges elected. And yes, they converge, and time becomes a problem, because instead of being elected in November now, justices are being elected in May, and so that does become a problem. So obviously, we are hopeful that we'll get a prompt resolution of that, so that everybody has some idea where we're going and how we can proceed. And I'm very confident that that panel will do a very good job. They're very good judges, and hopefully we'll get a prompt resolution.
Are you still trying to get the public funding too? I'm sorry.
Yes, sir. I'd like to go ahead and comment on it. The public funding is necessary in the eyes of the legislature and the governor who signed the law because it preserves the public confidence in the impartiality of the judiciary. 12 years ago in the judicial election, an organization called For the Sake of the Kids spent so much money that it really shook the confidence of the public in our judicial system. And that's reflected in the United States Supreme Court decision. Now, Ms. Walker says she calls the legislature past it, she has no problem with it. That's a bit disingenuous. The manager, guy that operated Mr. Blankenship's fund For the Sake of the Kids, that spent all the money 12 years ago, and I think spent more money 8 years ago, is now our campaign manager. And she has initiated litigation against Justice Benjamin and against my campaign. I don't know, I'm confident, as Justice Benjamin is, that the members of that panel will do the right thing, whatever that turns out to be. But the practical effect of her litigation is to put a damper on our campaigns. So it's disingenuous to say you're in favor of it when you're doing all that you can to prevent it from occurring. But the issue will be resolved. It's scheduled to be argued this coming Wednesday, and hopefully we'll have a decision on it. Thank you.
Ms. Walker, you want to respond to that at all?
Thank you. Well, first of all, there isn't any individual who is involved in For the Sake of the Kids that is involved in my campaign in any respect. So that's simply untrue. Second, we challenged the determination of the State Election Commission in the matter of the public financing because we didn't think that the law was being followed. That position was embraced by 2 circuit court judges in that process, and of course, as you know, it's a matter of litigation, and I have full confidence that there'll be a prompt resolution.
Okay, well, since we're sort of on the subject, just anticipating me a little bit, I'm wondering, Mrs. Walker, what has Justice Benjamin done to deserve the people who supported him 12 years ago now leaving him and support you? Why run against Justice Benjamin?
Well, I'm running for Supreme Court for the very same reason I ran for Supreme Court in 2008.
Mm-hmm.
You'll have to ask the folks that you're speaking of why they've changed their opinion to the extent they have.
Mm-hmm.
But, I believe just as strongly now as I did then that a fair and impartial judiciary is absolutely essential to moving West Virginia forward.
Mm-hmm.
I think to the extent we have unfortunately suffered with a negative perception about our courts and specifically our Supreme Court, I think I can be a positive influence in changing that. I'm an experienced lawyer. I've worked in private practice and in-house with the WVU hospital system. I've tried cases all over the state, and I believe I have not only the experience but the desire to see better things for the future of West Virginia, and that's why I'm
So you believe there is a negative perception of the state Supreme Court?
Yes.
Okay. Among the state in general, among certain people, or who has this negative perception?
Well, of course, we have seen the commentary about judicial hellhole. Great term, but that's the term that's been applied in the past. You can also look to a survey conducted by the Institute for Legal Reform, which surveyed 800 general counsel from companies around the country who do business in various states, rated the judicial systems on 8 or 9 various factors, including judicial fairness, judicial competence. And unfortunately, in that most recent survey, which was released, I think, in September, it's been done a number of times in the past. West Virginia came out 50th. That is one organization's opinion, but you asked for examples of a negative perception, and I think that that's where it is.
Well, along those same lines, you keep talking about the need to have an impartial and the appearance of impartiality, but I noticed you seem to be collecting a lot of endorsements from one end of the political spectrum. Can you tell us why?
I'm honored to have endorsements from a broad coalition of folks who are concerned about the future of the state. I don't know that there's one end of the political spectrum associated with it, but it includes elected officials and all kinds of folks who are concerned about the future of West Virginia. I don't think it's accurate to say that it's just one particular interest group at all. And I'm honored to have the support by those folks.
Could one switch gears for a moment?
Maybe.
Actually, I would like to speak.
Maybe, okay.
At some point.
Let's, what do you think, Ken?
Anything else?
Justice Benjamin?
Yes.
Go ahead.
Independence of the judiciary is the most important factor towards a fair, impartial, transparent judiciary, one that respects the people, one that respects everyone from any walk of life, regardless if they're an individual or a company. As I've often said, or Republican or Democrat, judicial independence is the key. As I've often said, a judge should not call a ball or a strike before the pitch is even made. That's important. Now, as the Charleston Gazette-Mail reported last fall, yes, the people that ran And for the Sake of the Kids do not support me. And to the extent that any support that they gave either towards me or against my opponent in 2004 was based on a notion that they may have had of influencing me, well, obviously they didn't, and that's their conclusion. And that goes to judicial independence. With respect to the respect which our court has in the United States, first and foremost, let me start within the state. The newspapers themselves have talked about, even the Chamber of Commerce saying that we've had a new direction. That's what it's been within the last few years. And yes, we are in an election cycle, I understand that now. But the people themselves overwhelmingly have been telling me, and I think it's reflected in the nonpartisan, bipartisan, complete breadth of support that I've shown so far, that they believe that we have restored a stable, predictable, independent, and fair court. And when we look outside the state, what we see are companies coming in like Procter & Gamble coming into our state. We're also seeing that our peers in other courts reflect that. In 2013, we were honored to host all of the Chief Justices of West Virginia here in West Virginia at their request. And today, we haven't talked about business courts or drug courts, as you know, my strong leadership in those two areas. We've now recently been asked by Virginia to help them develop their business court, to help them develop their drug courts. And with respect to access to justice, we're now recognized, even though we didn't start the program until 2009 when I was Chief Justice, we're now ranked within the top 20 access to justice programs. And that's really important to the people of the state, because that's where justice starts. And we've been able to shore up the funding of legal aid through that, as well as do reforms in workers' compensation that have been beneficial to everybody. So with respect to the standing in which our court stands in the United States, 2016 is very different than 2004. It's for the better.
Actually, I would like to, while we're on that topic, and change gears to some extent.
When I said if we could change gears, I didn't mean to chill this line of questioning, but rather I was struck with more than one notion running through. We began to discuss for the sake of the kids as related to public finance. And my query would be, to what degree does public finance prevent the sake of the kids? The device that was used in For Sake of the Kids, which was so-called independent corporate expenditure. To what degree does public finance prevent that?
Okay.
But I'd like to get back on the topic that, as Mr. Justice Benjamin just pointed out. You know, he said West Virginia, he cited examples of West Virginia having a better overall reputation and other states seeking West Virginia's guidance on things. And Ms. Walker mentioned the judicial hellhole report that West Virginia finally got off of from the Americans for Tort Reform Association. And Mr. McGraw, I direct this question to you. I remember years ago the Mandelitis decision was quite infamous in West Virginia and probably national judicial circles as considered bad for business in West Virginia. A lot of people thought it was highly unfair for business in West Virginia. And with West Virginia just recently getting off the Mandelitis, getting off the judicial hellhole list, you're like, if say you're running for to get back on the court, do you think your election would send a signal to the nation that no, West Virginia's judiciary is not changing back to we'll get back on it judicial hellhole list?
Well, you've raised a number of issues, and if I may, I should touch on the history that's behind this.
As briefly as you can, please.
Well, I'll do my best to be brief. For those who've researched the issue, they will notice that when I was a member of a 5-member court, that the Supreme Court of West Virginia was 1 year chosen as one of the outstanding appellate courts in the nation for having improved the quality of the administration of justice in West Virginia. That was concomitant with another organized representation that West Virginia was a judicial hellhole. Well, for those who have such a view of that, please remember that Article 3 of the Constitution, state Constitution, in the Bill of Rights of West Virginia, it says the courts shall be open to injuries of property, liberty, or reputation. Now, then comes along someone claiming, oh well, such frivolous things, lawsuits. In the procedure of West Virginia, there are remedies for what are called frivolous lawsuits, except that they must be proven in order for the remedy to be available. Now, with respect to the business of Mandelitis, I want to know who in this room believes that if a man who's running an industrial organization has the right to specifically disregard the laws and rules of safety that are designed to prevent life or death or injury to life or death, I want to know who believes that it's all right for the supervisor of that man to disregard those rules, expose, in the Mandelitis case, the man to a life-changing injury because of an intentional act. Now, who among us would subscribe to that? Who among us would subscribe to the proposition that it's all right to take the guard off of a saw in a place that they're pulling the saw back and forth to make cabinets and he cuts off his hand? Who among us would say that that's all right for that man to do that? Who says that it's all right?
Well, going back to the classic part of the accusation, I guess, of West Virginia being a judicial hellhole, do you think that was a fair part where plaintiffs and defendants getting a fair shot previously in the West Virginia.
I
Supreme
think
Court.
that the business of so-called judicial hellhole is a political term that is described to prejudice the community against the administration of justice as it is perceived by the community to be administered. That's what I think. I think that that's I don't know, another political term that I can think of that is a political term is right-wing extremism.
With regard to the judicial hellhole, I started practicing law, opened up a sole practitioner on my mom and dad's front porch with a manual typewriter. And in 3 weeks, I was tried a jury trial in the Circuit Court of Clay County. I've been trying jury trials for 43 years. The juries are fair, and for people to say that a jury trial in West Virginia leads to a judicial hellhole is a sham perpetrated by some entity to shame the legislature or other people into say the judiciary wasn't fair. I've never been involved in an unfair jury trial ever in my career. And I would say we have the greatest jurors in the world, and the judicial hellhole term was never, ever deserved by any of these people sitting here before.
Mr. Wood, do you have any thoughts about the perception of the Supreme Court?
I think the judicial hellhole term is, has been stated, a political term. It really paints with a broad brush our entire judicial system, and the complaints that the people using that term are seeking to address don't come from the judicial system. They come from the legislature and the other branches of government. So it's really unfair, especially to our trial court judges. We have an outstanding cadre of trial court judges, and to say we're part of a judicial hellhole is wrong. The people who promote and use that term, Ms. Walker mentioned a moment ago, survey of general counsels of multinational corporations that rated us low. Those people have a political agenda, and that's the use of that term. I think that certainly at the trial court level in West Virginia, people that are not influenced by propaganda like judicial hellhole have a good opinion of the judiciary in this state. The residue, the fallout from the for the sake of the kids thing did put a black mark on our judiciary, but I think we're moving past that.
Well, we moved past it, but the question still remains with respect to public financing. How does the public financing prevents that kind of thing? It doesn't. And if you don't believe it, you are.
The criticisms, I know are, some people say they're political, some say they're monetary, they've got, there's an agenda to them. But I think it's also important as a public official to note that part of what makes a better court is the ability to go out and listen and hear criticism or to hear suggestions. I've made an effort of my time on the court to go out and talk with, and more importantly, listen to people about their system, because in essence, when it comes down to it, the court system is the court system of West Virginia. I think we do need to be very, very mindful that there are groups out there who have agendas, because that's what they're in, that's why they're formed. And that, yes, we have to be concerned about criticisms based on scorecard justice. We should never have scorecard justice. And yes, those organizations do have, that's part of what they do. So we do have to be mindful of that. But we also have to have our ears open as elected officials to hear what can make the whole system better for everybody. And that is especially important in the area of procedure. 12 years ago, we did not have a business court in West Virginia. In 2008, I took our court administrator, Steve Canterbury, over to Delaware, because they did have one. And we learned from them. And we started the process in 2009 of implementing the court, which we now have. And as I said, now Virginia's asking if we can help them get business court. Business court does not affect consumers at all. It's business-to-business litigation. But what we did was we responded to a desire by business to have a more efficient way of resolving their dispute with finality and with predictability. And it's been an overwhelming success. And for them, one of the most important things was that we recognized the cost of litigation. Not just the cost to attorneys, but the cost in discovery that was unnecessary. And we put together a program with a lot of input. We listened, and we got a lot of input. And we created a system that they love. And in most cases, those cases are litigated within 1 year. That's far less than a lot of arbitrations and a lot cheaper than a lot of arbitrations out there, or alternative dispute resolution. That's part of this. The increase in drug orders, again, listening to the public, what their needs are. We can make changes. It doesn't affect the substantive side of law, of deciding cases based on the rule of law. That doesn't change. But we, as administrators of the court system, have a very large role in how we can make the system more efficient, not just for the government and the taxpayers, but more importantly for the people that use the system. And that's something that we do have to listen. We don't necessarily have to give credence to scorecard justice folks, but we do have to listen.
Ms. Walker, is judicial hellhole a political term used to prejudice people?
In my view, it doesn't matter whether it's a political term or however else you might categorize it. It is a term that has been applied in the past to the West Virginia judiciary. And so I take it as a perception that we have to be realistic about and try to move forward and change. And to change it is not to decide cases in favor of a particular constituency or a particular interest group. It's to decide cases based on the law alone. For folks to have confidence that they can come before our Supreme Court and have their cases heard fairly and impartially, and that they can raise concerns, whether it be with the Judicial Investigation Commission or otherwise, without any fear of retribution or name-calling or retaliation. I just think we have to be realistic about the criticisms that are leveled against the West Virginia judiciary. We can, listen to them, as Justice Benjamin said. I think you have to listen, but you have to be realistic about it and do what's necessary to move forward. And in my view, again, it's very simple. The rule of law, deciding cases fairly and impartially, giving folks confidence that they can come before the court, have their disputes adjudicated, walking away knowing whether they win or lose, that they've been treated fairly.
You said it doesn't matter whether it's a political term. Is it a fair term? Is it an accurate description?
It's not for me to judge. It is a description that's been leveled, and so I think you just have to move forward from there. Is it a fair term for a lot of things, that are labels that are applied in West Virginia? We can certainly complain about whether a label that has been applied to West Virginia is fair or not, but I think we need to look at it and see whether it's reasonable to think about moving forward and changing it. And I am, very much energized by the prospect of moving forward.
I guess just to follow up, if you think we need to, look at how to change it, why would we need to change it if it's not an accurate term? I guess is the question. I don't know if it's accurate, but if you're unwilling to say whether it's accurate or not, why would we make changes?
Because it's been a term that's been applied. So I think we need to look at what we can do. Certainly we can't control what people are saying, but if we can have the utmost confidence in the fairness and partiality of our judiciary, then we've done everything we can do to make that change if it's possible.
That this Posnerian theory of law being determined on the basis of its economic effect is a highly controversial notion in jurisprudence. Posner's a former professor at the University of Chicago, who has written articles and books on this notion that the administration of justice ought to be very sensitive to the effect on the economy as opposed to individual justice, on the theory, I guess, that the community is better off recognizing that certain kinds of things are just the cost of economic enterprise, such as cutting somebody's hand off to make a carpet, to make a cabinet cheaper. But the Posnerian theory is a highly controversial proposition.
This might or might not relate to our current discussion, but I was reading your candidate form that you submitted to us, Mr. McGraw, and there was the fourth question you said, a current issue facing the Supreme Court is the perception of philosophical imbalance.
Yes.
And I wondered what you meant by imbalance.
Well, you've heard one expression of it here from Justice Benjamin. Let's do a little background. In the history of West Virginia, our court consisted first of 3 people, then 4 people, and then 5 people. And the changes that occurred in expanding the court was the result of people feeling that the philosophical balance of the court needed to be changed. This is always a problem in the selection of judges and so on, the idea of philosophy. I mentioned a while ago that, stick with language. Philosophy means, of course, the love of knowledge. And sometimes accumulated knowledge seems to have biases. And in the case of the current court, the bias is probably toward in the direction that has been described here today by at least 2 of these aspirants. In my case, the next logical question would be, what kind of philosophy would you be talking about? And I put it like this. Ill is a word that connotes some incipient evil, perhaps, or wrong. But I wouldn't want to be thought of as illiterate. I wouldn't want to be thought of as illogical. I would not want to be thought of as illiberal. But I would accept as a good word, illuminate, and the court needs more illumination. And really more dedication to the notion that the government is an entity and that law is an entity that's designed to enhance the quality of civilization with good people working through proper processes to do so, and in ways that do not damage, hurt, or diminish their fellow citizens. It's a kind of an old notion. It runs all the way back maybe to the Proverbs or something like that. It's an old notion, that idea. But when I talk about philosophy, that's what I'm talking about. And in West Virginia, in the current time, we are in difficult times economically because the world changed.
I don't mean to belabor the point, but I wanted to go back just one moment because Ms. Walker, I don't quite understand your answer on the judicial hellhole thing. It seems to me, we have this accusation, West Virginia is a judicial hellhole. There could be, you could say on one hand, this is fair, this is maybe a correct accusation, we should think about doing things differently or making some changes. That seems to me one option. The other option seems to me to be, no, this is not fair, this is incorrect. I think the kind of general way of what we're doing things is fine. But it seems to me what you're saying is that you don't make a judgment on whether it's correct or incorrect, but are saying we should make changes anyway. Is that, am I interpreting that right? Because that doesn't seem to me to follow.
I'm not sure how else I can explain it. I'm very simply saying that it's a perception, a criticism that's been leveled, that I think we need to take into account as we're moving forward.
But you don't make any judgment as to whether it's a valid criticism or perception.
Well, that's the thing about perceptions. I mean, it's someone else's perception. It's not for me to determine whether, their perception about the court is accurate or not. It's for me to take that into consideration.
I guess to go one step further, if we, are there other perceptions about West Virginia that you think that you don't know whether they're correct or not, but you think we should make changes? Because, if someone says West Virginia's, environmental laws are way too lax, and we let coal companies get away with way too much or something like that, and you say, well, I don't know if that's right, but we should make changes. You see what I'm saying? Like, I don't understand the notion of we need to make changes based on this perception, but this perception, I don't know if it's right or not.
What I'm focused on is running for Supreme Court Justice. I believe I can have a positive impact on the future of West Virginia. We'll be electing a justice who's going to serve until January of 2029. I guess I leave for another day a discussion of whether environmental laws or other challenges that have been leveled might be accurate or not accurate. But I'm hoping to convince the voters of West Virginia to support my candidacy because I'm cognizant of those perceptions. I'm realistic about the challenges we have in West Virginia, and I'm looking forward to contributing to an improvement in the fairness and impartiality of our judiciary and to personally adhering to the rule of law.
Just change subjects totally for a moment. We saw the state nuisance law come up in the legislature this past session, and the nuisance law is, centuries old, protects our enjoyment of our property. Do you have any thoughts on whether West Virginia should change its nuisance laws? And whoever would like to go first, just give me a sign.
I'll start
Okay.
by saying that I'm not comfortable commenting on what the laws are, what they should be, in accordance with the Code of Judicial Conduct. We are limited on our ability to comment. I mean, I leave for others to.
Right.
Ms. Walker is absolutely correct. I'll leave it to others if they want to comment. But obviously, that's a legislative domain area, and it would be very difficult, if not inappropriate from an ethical standpoint, for a judicial candidate to comment on something that might come before us.
Yeah.
And I can pretty much guarantee it will. That being said, though, it's also important when we get questions like this, not to show disrespect, because it is an important issue, but it also is one that we must respect the form of government we have, which is it's a legislative area, and just as we don't want them telling us how to decide cases or administer the judicial system, we need to be very careful about what we tell them to do with their domain.
Sure. Well, maybe I can ask the question in a more constructive way. So there's been a flurry of nuisance lawsuits against operators in the gas industry. Can the courts handle these lawsuits?
Well, I think certainly we would likely get those cases. We just a few weeks ago at West Virginia University, the case is not out yet, discussed a case involving trucking regulations in the city of Morgantown. And that, I think, did touch on that area to some extent. So yes, when I answered before, that's what I was thinking of. Yes, those cases will come before the court. And yes, they will be decided. And a very good example is that recent case that we just argued at the West Virginia University School of Law on an issue which I think is very close to what you were talking about.
Anybody else want to have anything to contribute on that subject?
I feel confident the court system can handle all the cases.
Okay. All righty.
Can I go back to one other?
I would dissent on the proposition that I have heard here that deals not necessarily with nuisance, but that the courts don't want the legislature telling them how to interpret the law. That is a frequent occurrence in statutory construction. One that I think of particularly is that in the workers' compensation law that covers Madeline, it says that the law shall be liberally construed, presumably in favor of the claimant. That's just one example of the legislature telling the courts how to interpret them.
Mr. McGraw touched on the philosophy of judging, and I think that that is a very important thing that is one of the wonderful things that we have in West Virginia with respect to election of judges. It's very difficult for the candidates sometimes to get the message out to the voters, and I'm sure I can speak for all of us that we really appreciate the opportunity to talk here because we do get an opportunity to talk about and let people see what our philosophies are. For me, to get back to your question, we serve the people best when we serve their law. It's the rule of law, and I believe that we should have a reverence and a respect for the Constitution as judges. That's where it begins. We need to defer to the legislature on policy matters to the extent possible. That is part of what I believe. I think that we serve the people best when we do it within that when we judge within that framework, because that then creates a stable foundation upon which a state can grow. I recognize that that's my philosophy and others will disagree, and it's that disagreement that I think is important so that the people get the court that they want. I've got a record of over 11 years on the court. Mr. McGraw has a record of 12 years on the court, and they are different records. And I think it's important that I'm not saying his is wrong, and I know, and he's not saying mine's wrong, I don't believe. But it does give the people an opportunity to see, to put fact behind what they think that they want for their court. And ultimately, that's what it comes down to. We have an election system in this state, so it's not a committee picking judges. It's not a governor picking judges. It's not like in Virginia where the legislature picks the judges. We're the people pick the judges, and I think so we try the best, I think, as we can in candidate forums to try to discuss those philosophical differences. Obviously, with Mr. McGraw and myself, it's pretty easy because we've got the set record.
We have used our hour and we really appreciate it. I do want to give you each, just to extend our hour by 5 minutes, give each of you just a 1-minute wrap-up of why you think the voters should elect you to the position of Justice of the Supreme Court of Appeals of West Virginia. So.
43 so years of practicing law in the state of West Virginia, representing a broad cross-section of plaintiffs, defendants, prosecuting cases. I just have a unique experience. I believe I can bring some common sense and some good judgment to the court.
Thank you, sir.
When I decided to run 12 years ago, I felt the court system was broken, and I ran because I thought I could do things to help change it. Today we have a stable, predictable court system, one that is based on the rule of law, but it goes beyond that. And we also have been able to create dividends for the state of West Virginia through that stable, predictable system. And that's in the form of drug courts, access to justice, truancy initiatives, business court, the domestic violence database. These have been all things that didn't exist 12 years ago. And in my next term, what I want to do is not only maintain what we have developed through the court with respect to how we judge, maintaining stability and predictability of the system, but to expand upon those special programs even more, so that we soon will have a statewide adult drug court, which has saved a lot of lives and save the taxpayers $25 million per year in incarceration costs alone, but also expand that to statewide juvenile drug court, to statewide veterans court, and also to expand access to justice, truancy programs, and hopefully continue the very great success we've had in business courts.
Mr. McGraw, 1 minute, please. Up to 1 minute.
I'm a candidate for Supreme Court in order to continue my calling of service to the people of West Virginia on a basis that is intended to improve and add constructive efforts to the community to make the place a better place to live for the people from whom I come and for the people with whom I associate and for the people who will come after me. I am running to pursue my calling to that end as my legacy. Thank you very much.
We're in a challenging time in West Virginia, whether you're talking about the drug epidemic, our budgetary challenge at the state level, or just folks all across the state who are unable to find employment. I'm running for Supreme Court because I think I can make a difference in the future of West Virginia by a justice on the Supreme Court, adding to the fairness, impartiality, and just confidence in our judicial system. I'm committed to that, just as I was committed previously when I ran, and I'm looking forward to continuing to talk to voters, continuing to work hard to earn the confidence of West Virginians as we move into the future. So thank you so much for the opportunity to talk to you all today.
Thank you. Thanks for the chance to do this. Public service has been a major part of my life. I served, as most of you know, 26 years in the state legislature. I'm a retired colonel from the Army National Guard. I worked as a prosecutor. In fact, I think I prosecuted West Virginia's most notorious living criminal, a fellow named Ron Williams. I convicted for killing a police officer in Beckley. He later escaped from Moundsville. You may recall he murdered off-duty state policeman Philip Kestner, and then was finally apprehended in Arizona, where he committed additional murders. But public service has been a major part of my life, but most of my public service has been on a part-time basis as a practicing lawyer and a member of the legislature. And as a practicing lawyer in Beckley, I've seen every type of case you can imagine. My clients are normally citizens and small businesses, and I get a great deal of satisfaction from helping people to deal with complex problems in law. But I think the experience I have and my commitment for public service ideally qualify me for Supreme Court. Thank you for your consideration.
Thank you very much. Thank you all. Thank you.
Thanks.